I'm open to any questions that you may have. So I'll hand over to Kev.
Thanks, Tony. I think that was really informative. So we hope that helped those that are watching today. And I think particularly that the 5-step process as well, once we embed that in our minds, that really helps simplify things. So yes, we have got a few questions. Probably not surprisingly to you around RAMs. So we've had a few questions around that. Let me maybe grab one that sort of covers everybody's questions around that as much as possible. So is a client still likely to be held responsible even where he has appointed a suitably qualified and experienced contractor, particularly as the client, in most cases, will have no expertise in the detail of what's likely to be involved and how the risk should be addressed?
The answer is yes, under Section 3. However, you need to do, as I mentioned, you need to be able to make some form of assessment of the RAMs, their intended way of working, the method statement based on a risk assessment. You're not meant to be experts in those areas, but be able to apply general requirements. So as I mentioned, working at height, if the work involves working at height, you should have some understanding of the hierarchy of control when it comes to working at height. So you need to have a broad understanding, but not an expertise in those areas. Because let's be honest, that's one of the reasons you appoint contractors, because you don't have the expertise. But you should be able to have some understanding of the nature of the hazards and risks associated with the work, and make sure that basic health and safety requirements have been addressed as part of that work.
Okay, thanks, Tony. Another one then. So this is about enforcement. So if nobody gets hurt, does that mean that the regulator can't take enforcement action if there's a non-compliance found?
Again, they can. The way the health and safety legislation is written, failure to do the correct assessments or meet the requirements is the offence, not because there's an accident. If there is an accident, that's what's known as an aggravating feature. It basically means that if you're prosecuted, the consequences are worse than if there hadn't been. But simply not being compliant in itself is what you can face enforcement action, whether or not that's the serving of enforcement notices or prosecutions by the regulator.
Okay, right, that's fair enough. One from myself, just it's probably an opinion really, Tone, that I'm trying to solicit there. Is there, would you say having the correct controls in place not only helps the facility managers, but also clarifies things for the contractors as well?
It does. And I will also expect it to make them more health and safety conscious if they know they've got a client who is health and safety conscious. By being asked to do the right things. So, for example, one thing that contractors will often do is produce what are known as generic RAMs, where they don't actually consider the workplace they're going to be working in. If you have a client who challenges those, it often forces them to think about health and safety more robustly. And it also tends to drive up their health and safety performance whilst on site.
Okay, that's fair enough. Yeah, that makes sense. Another one that's just come in. If there is an accident, does the client have a legal duty to report it to the regulator?
Okay, under RIDDOR, which are the reporting regulations, the duty to report an accident rests with the employer. So it's up to the contractors to report the accident to their own employees. There is a quirk. If it's what's known as a dangerous occurrence, this is where nobody's actually been hurt, but for example, you get a significant gas leak. That's what's known as a dangerous occurrence. For a dangerous occurrence, it's actually up to the client to report the dangerous occurrence, not the contractor.
Okay. Okay, that's interesting.
It's predominantly set up for things like factories where the client is present and the contractor's employer may not be present. So it's a way that it's reported quicker to the regulator. But it does have knock-on effects where in things like facilities management, where you don't even have, potentially you don't even have the client present as well.
Okay, thank you for those answers. I know some of you have also put in some maybe more specific questions to certain circumstances you've got. So we're looking to answer some generic ones as much as possible today to help. But if you've got the specific ones, then I'm sure if we fire those across to Tony on his email, he'll be able to sort of help further with advice around those specific circumstances as well. And so I think that concludes the Q&A session as much as possible today. Should we have a look at the next steps then? So what are the next steps for us? So as I just said, so if you do need some advice, then please contact us. Tony will be able to sort of delve a bit more deeper into any questions and help you a bit further on that as much as possible. We will be sending you a replay, and that will be available on the website. And that will be together with the checklist that we're going to provide as well, which is the 5-step process that Tony mentioned within the presentation. And we're also looking to keep you updated as much as possible around this information. So we do ask that you follow us as much as possible on LinkedIn. Have a look at our post. And if you like the information, then please like or comment on those as well.